that the following day, their head over Beshe sent Meshawa and his younger brother to go and inquire and request back. According to DWC, that Zaki Uba told their head that he will kill him because he believes that he has a hand in the killing of Uba's family. That upon return home, he told him to go to his mother's side and inform them. Since his mother's people were not satisfied with the allegation against him by Zaki Uba, and he should summon Zaki Uba to court to say those things on oath, DWC stated that he served him summons at Magistrate Court, Lafia, that on the hearing date, Zaki Uba came with police at the court and he was arrested, that he was again interrogated at the state CID, and he made a statement and told them that he did not kill anybody in Zaki Uba's house because his house was not close by, and that he told them that he has never fought before and that he has never been taken to a police station before. Under cross-examination, DWC confirmed that he heard about the incident of killing in Zaki Uba's house and that the head sent Mashawa to Zaki Uba and made him return. And upon his return, he reported that Zaki Uba said he and the defendants conspired to kill relations of Zaki Uba. More water. I'm bringing it down. I'm bringing it. At the close of the defense of the defendants, the court ordered counsel to file their final written addresses, which were adopted on the 15th day of March 2023, and was later adjourned for judgment. Then the counsel for the defendant, Yopen Esquire, in his final written address, formulated 3 issues for determination thus. 1, whether the complainant has proved the offense of criminal conspiracy against the defendant beyond reasonable doubt. 2, whether the complainant has proved the offense of culpable homicide with death against the defendant to justify a conviction for the offense. 3, whether the defense of alibi does not affect the defendants in the circumstances of this case. Arguing issue 1, the legal counsel for the defendant stated that the complainant has failed to prove the offense of criminal conspiracy against the defendant beyond reasonable doubt. He referred the court to the evidence of PW1, PW2, PW3, and PW4, and the B, D, F, and H, and started the case of Yakubu versus the state citation as provided. Arguing issue 2 and 3 together, the legal counsel for the defendant submitted that the complainant has failed to prove the offenses of culpable homicide punishable with death against the defendant beyond reasonable doubt to justify a conviction for the said offenses. That the defense of alibi avails all the defendants in the circumstances of this case. He started the case of Aliu versus the state citation as provided, among other cases in support of his submission, and referred the court to section 220 and 221 of the Penal Code. Counsel also submitted that this honorable court is entitled to look at its own record of proceedings and see the statement of the nominal complainant Zaki Uba, dated 8th of September 2019, attached to the motion ex parte for leave to refer it, which statement forms part of the records of this honorable court and what Zaki Uba said in that statement. He also referred the court to Exhibit A and E, and urged this honorable court to apply the inconsistency rule against the complainant and discountenance the testimony of PW1 concerning the identity of the offenders, which he attributed to the defendant as a bundle of lies and afterthought. The next counsel for the defendants concluded his submissions on the following points. 1, the complainant has failed to prove the offenses of criminal conspiracy and culpable homicide against the defendant beyond reasonable doubt to justify a conviction for the offenses. 2, the extrajudicial statement of PW1 Mr. Clement Pev and his direct evidence in court identifying the defendant as a murderous are belatedly made and therefore too suspicious to be acceptable. The evidence adduced by the complainant is also contradictory on the fundamental issues such as the identity of the offenders and therefore manifestly unreliable. 4, furthermore, the complainant has failed to call vital witnesses such as the nominal complainant Zaki Uba, as well as his children and junior wife, who saw the attackers and witnessed the commission of the offenses, which is detrimental to the case of the prosecution. That, on the contrary, the defense of alibi availed the defendant in the circumstance of this case with respect to the offences charged. The next counsel for the defendant urged the Honorable Court to dismiss the charge and acquit for the defendant. The next counsel for the prosecution, M.I. Downley, T. Esquire, in his final address formulated a long issue determination thus: whether the prosecution has proved its case beyond the defendant's beyond reasonable doubt. Arguing the loan issue, the next counsel for the prosecution submitted that the prosecution has fulfilled the requirement of proof beyond reasonable doubt in a criminal trial. The burden is always on the prosecution to prove the guilt of the defendant beyond reasonable doubt. Cited Section 1351 of the Evidence Act, cited the Supreme Court case of Emeka v. the State, citation as provided. In support of his submissions, and urge me to take into consideration the circumstances that led to the commission of the offense alleged against the defendants, in holding them guilty of the offense of criminal conspiracy. On the second charge framed against the defendant being culpable homicide punishable with death, Sunday Counsel for the prosecution submitted that in proving these necessary ingredients, the prosecution can rely on direct eyewitnesses' account of the incident or circumstantial evidence, such as the case of Keleke versus the State, Dowodu versus the State, citation as provided, among other cases in support of his submission, and also made reference to the evidence of PW1 and Exhibit A to G in support of his submission. And the counsel for the prosecution submitted that the argument of the defense counsel in paragraph 4211 to 4215 of his address is unfounded and cannot stand the test of credibility, as the evidence adduced from PW1 and those of the defendant succinctly clarify the issue of description of who the actual perpetrators of the offense are. The next counsel for the prosecution also submitted that the submission of the learned counsel to the defendants in paragraph 4.3.1 is an attempt to whip sentiment and emotion into this case. The next counsel for the prosecution further submitted in response to paragraph 4.33 of the learned defendants counsel address that the Cesar Kiuba in Exhibit E identified one of the defendants who, after the attack, came to check Isaac Kiuba was still alive and shook his head and left. The next counsel for the prosecution concluded his submission on the following points. The prosecution discharged the burden required of it by calling an eyewitness whose evidence has not been impeached or discredited. The defense of alibi raised by the defendant is a daydreaming, as the said defense has been defeated by the evidence of an eyewitness who fixed them at the scene of the crime. More so, there had been inconsistent testimony by the defendant witness, and referred the court to the case of Ogongon versus the State, citation was provided. That there had been inconsistency, cogent and reliable explanation offered by PW1 as to the timing of his statements, in addition to the explicit identification of the defendant in A, G, and E respectively. There had never appeared to be contradictions in Exhibit A, G, and E, and assuming without conceding, even if there appears any, same does not go to the roots of the case. That the prosecution is not required to bring forth hosts of witnesses, rather it is required to bring cogent and reliable witnesses to prove his case. He urged this honorable court to convict the defendant. So, having summarized the evidence of the prosecution as well as that of the defendant, and in order to determine the fourth count charge against the defendant, it is pertinent to state here that it's an established principle of law that where a count of conspiracy is based on the same facts or set of facts as those of the substantive offense, the court should first deal with the count of the substantive offense. In the instant case, the first count is for conspiracy to commit felony to wit, culpable homicide. The second, third, and fourth are for the actual offense of culpable homicide. For the evidence adduced by the prosecution, the count of conspiracy is based on the same facts, a set of facts as those of the substantive offense of culpable homicide. And where that is the case, courts are enjoined to deal with the substantive charge first. This is just as well because should the substantive charge be unproven, there will be no conspiracy and abetment to commit the substantive offense. See the case of Latif versus FRN. Citation as provided. Furthermore, and by virtue of section 1351 and 2 of the Evidence Act, is the commission of a crime by a person